Court of the City of Poetry. I am Officer Pac-Man, sitting in for Judge Legit, who is sick today. I call the case of the State of Charter versus Eli Jones. Mr. Jones, you were caught red-handed using your cell phone in a school zone. Since it was obvious you committed this crime, I'm going ahead to find you guilty as charged by me, since I was arresting officer. Your sentence is...
Objection! Where is my legal counsel? Where are my witnesses? I have rights. What is my charge anyways? I have no idea what's going on here. I was left in the cold for 6 hours, handcuffed, I remind you.
Order!
I still am.
Order! As I was saying, your sentence is a donation of your vehicle to the police department.
My Jeep.
10 lashes with a bullwhip, and 10 years of hard labor for the city under our community service program. That will teach you a lesson. You can start today by mopping the floors.
Objection. My Jeep.
This is Petunia Ratterbrick with WAAA. I'm here to interview Judge Hopeman, an expert in constitutional law. Judge Hopeman, what most disturbed you about this current case?
Well, I've reviewed it and taken several notes. The most concerning is the extraordinary constitutional violations, including Amendment 4, the right against unreasonable searches and seizures, and the right to have a warrant supported by probable cause before a person can be arrested and property searched. A traffic violation generally doesn't give police the right to search the inside of an automobile. In the case of Carroll versus United States, an exception was made to the Fourth Amendment right where the vehicles may be searched without warrants if there is probable cause to believe that contraband is inside. This incident was clearly a typical traffic stop with no search warrant, and the vehicle was seized by driving it off.
Yes, that is correct. WAAA later learned that the officer drove the vehicle to his house, ate lunch, before going back to the defendant, who was handcuffed in the cold for 6 hours. What are your comments on that, Judge?
I am horrified. Our Constitutional's Eighth Amendment prohibits cruel and unusual punishment, was defined as unnecessary and wanton infliction of pain by the case Ingram versus Wright. The judge's sentence of taking the car, hard labor for 10 years, plus handcuffing in the cold for 6 hours for a traffic violation is clearly in violation of the Eighth Amendment. Plus, the case of Miller versus Alabama determined that young people are less culpable than adults and more likely to be able to change over time, which is why juveniles should be treated with more leniency, which this young man wasn't.
Yes, Judge. Even a common citizen can see that this punishment is excessive. I guess that's it then.
I wish it was. I also see a violation of the Sixth Amendment requiring an impartial jury, the right to a public trial, to be informed of the nature and cause of the accusation, to have witnesses and a lawyer. In this case, the executive branch, the police officer, made the arrest and later acted as a judge, not an impartial fact finder. The important constitutional case of In re Murchison stated a fair trial is a fair tribunal is a basic requirement of due process. In an older but famous case, Lisbaugh versus California, as applied to a criminal trial, denial of due process is a failure to observe that fundamental fairness essential to the very concept of justice. Clearly, this case violated 3 amendments. An immediate appeal is in order and other charges against this public official.
Thank you for your time, Judge. WAAA will be following this case as it develops.